you the foreperson?
Yes, Your Honor.
Have you reached the verdict?
Yes, we have.
All right, would you please stand and read your verdict?
We, the jury, find the defendant, Brandon Vandenburg, count 1, aggravated rape, guilty of aggravated rape. Count 2, aggravated rape, guilty of aggravated rape. Count 3, aggravated rape, guilty of aggravated rape. Count 4, aggravated rape, guilty of aggravated rape. Sorry, out of order.
That's all right.
Count 5, aggravated rape, guilty of aggravated rape. Count 6, aggravated sexual battery, guilty of aggravated sexual battery. Count 7, aggravated sexual battery, guilty of aggravated sexual battery. Count 8, unlawful photography, guilty of unlawful photography.
All right, let me ask you this question, number 11. Is that your considered verdict?
Yes, Your Honor.
All right, please be seated. I'm going to ask each of you.
Well, it was a very poignant moment in the trial as you just watched the verdict being read, and what can only be described as the deflation of Albert Perez, who is an attorney from California, who's like a father to Brandon. I was asked on Twitter what must have been going through Albert's mind, and it had to have been a very tough moment for him, because there was one thing that it didn't appear that any of the Californians, and I mean Albert or Brandon, could ever wrap their mind around the fact that Brandon had committed a crime, and that the only way to win the case was to say that while he committed a crime, he did not commit the charged offense. But you have to concede the commission of a crime, which they were never willing to do. One of the first mistakes of that the defense made. Now, the prosecution tried a brilliant case. They won the case from the very beginning, right down in seating a majority of female jurors, because we talked about this, Austin, that we had focus grouped the facts before the first trial, and that it focus grouped terribly to female jurors. And here the prosecution was able to get 9 female jurors initially seated among the 14 that made the trip to Nashville. So it was a total state victory. And you have to like that for Tom Thurman, who is the most storied and talented and best prosecutor in the history of the state of Tennessee. And he was very methodical in this trial. He was skilled, and you saw the experience and just the raw ability. And in the end, I really think this jury believed Tip McKenzie. And if people want to know what the difference was between Brandon Vandenburg's verdict and Beatty's verdict, is the Hamilton County jury, which was almost exclusively white, that's just a fact, it was, didn't believe much, it appears, of what Tip McKenzie told them. But you see, Tip McKenzie's testimony in this trial was buttressed by these statements of Vandenburg that came in, for which he gave no explanation. And I think that jury believed Tip McKenzie right across the line. What are your thoughts?
Well, I mean, as you're talking about General Thurman, and then also Jan Norman.
She did a fantastic job. Roger Moore
Roger
always
Moore
does a fantastic job, and he did a
very
fantastic job
tough.
here again.
That's
yeah.
a tough team. You wouldn't want to go into court and face them if you're the defendant, because you better come with your game ready. And we talked about last week about just the defense, and who you asked me one time who would you like to have, and I said Bolin. I thought Regan. I thought he was very good. I may have not known enough about him and may have underestimated some things and watched him, but you know, I was stunned at the at the strategy that they used in trying to basically not put any witnesses on and just go straight for acquittal and everything, and try to get off on everything and just hope that jury and plead with them and say, please be open-minded and listen to me, when you hadn't put anything into the record or done things that would show that the government or their theory is that we have Charlie Manson or Monster. He's drugging people. He's taking them down there. He's serving them. All the things that they're saying, that was their narrative, and that somebody didn't come back.
Their narrative bore out in the proof.
Yeah.
Unfortunately for the defendant, it bore out in the proof.
Well, unless somebody could come and present some other information that might have not made that be.
What else do they have?
I don't know. That's what I was waiting to see, what they would present. But anyway, I would have been interested to see what you would have done differently than what we saw there, because you at least went through the first trial.
I talked to Chris Bungard, and I'm going to tell you, you may not want to know, but I'm going to tell you because anyway, I'm going to do it. I told Chris Bungard before the defense put on any proof, and he's an investigative journalist with Channel 2 News. And I said, Chris, for them to have any chance at all, the defendant has got to put Beatty's conviction into the record. Then they have to call Beatty in their case and have the court declare that he's unavailable because of a privilege against self-incrimination. And then they needed to read his testimony from the first trial, where he said that he basically acted alone under no one's direction, solicitation, wasn't aided or attempted to be aided by anyone. Then you look at the jury and say, you know, this guy was acquitted of the charged offense in 4 of the first 5 counts. The only count in which he was convicted was the count they saw on video, and he just told you that he wasn't directed, guided, solicited, aided, or abetted by anyone. He just said that. So that should give you reasonable doubt that he committed the charged offense. Maybe he committed something lesser, but that should give you the reasonable doubt that he committed the charged offense in all of the first 5 counts, because the other actor is not here, and we didn't hear from Mr. Banks. I told Chris, I said, if they don't do that plan, there's really no other path to anything other than dismal destruction. And you can't, and you know, Austin, you contacted me and told me that Perez's closing argument was basically all or nothing.
Yeah.
You know, you should convict him. Well, this jury was never going to convict him of nothing. And that was a huge strategic error. And you have to wonder how much. I asked you during the trial, is Albert Perez too close to this defendant to give him legal representation that is legitimate? We asked that question several times during the week, because you can't look at this jury and say that Brandon did something very, very wrong. In fact, he probably did exactly of what he was ultimately convicted. The government's theory was well laid out, well reasoned, and was proven. There was proof, as Jan Norman laid out in her closing argument, as she kept playing proof that had come into the record for each tenet that they asked the jury on which to convict. I mean, they gave the jury every reason to do it, and the jury did it. And it was, in light of what came into the record, it was an appropriate verdict. And the reason that I'm giving a critique of the defense is because now the issue becomes whether the defense was so ineffective that having them defend you violated your Sixth Amendment right to counsel. That's called post-conviction relief, and that's going to be the next thing that Brandon is going. Brandon will now turn on his 3 attorneys when all of the appellate remedies are satisfied. Now, he'll appeal. He'll go to the court of criminal. Now, he'll be in custody the whole time this is going on. They will not set an appeal bond for a Class A felon who's been convicted of multiple Class A felonies, because if you let him out on appeal bond, what's going to stop him from running? So they're not going to let him out. He'll be serving, but they'll file an appeal. I don't know what there is to appeal, but they'll file one.
Double jeopardy, they've already
the
talked
double
about.
yeah, that's it. The double jeopardy argument, they're going to appeal. They're going to say, now the Court of Criminal Appeals, here's my rather inside, the Court of Criminal Appeals is not going to, you're not going to prevail on that argument, even if you're right, because the Court of Criminal Appeals is mindful of the fact that if they ruled in favor of the appellant on that issue, they're letting out a guy that has been convicted of 5 ag rapes of an unconscious, helpless, and amazingly strong victim. And they're not going to do that, no matter how good your argument is. I'm not sure the Supreme Court of Tennessee would do it, but they're going to exhaust all their appellate remedies. But when those remedies are done and exhausted, Brandon will turn on his lawyers. He would have turned on me. in the same shoes. This happens in every criminal case. And Brandon will file a petition with the court to award him a new trial because his counsel was ineffective. And now the counsel that he's been hugging and that he thought was great, the one that promised they were going to come here and kick some butt, and they didn't say butt, is now going to be defending themselves against Brandon's petition that their defense was so ineffective and so ineffectual and so poorly strategized, they were so poorly prepared. And one thing that Brandon will complain about is he'll say, well, they didn't even put on any proof. He'll say that. They always say that in a post. Well, he didn't put on any proof. He should have called this witness and that witness and this witness and that one. So anyway, that's going to be coming next.
That's speculation on your part that that's what they would
Oh, no,
do.
that's going to happen.
Oh, you think it'll happen?
Yeah, that's going to happen. He will file, I think, does anyone have any idea what his sentence will be? The state says that they're going to pursue consecutive sentencing. If they do, Brandon could get 40 years.
Yeah, I'm thinking that's what's going on.
It's an event that occurred. It's an event that occurred all in one night. Generally, it would be sentenced concurrently. I don't know what the state's argument will be for consecutive sentencing, but they will have one.
Jan Norman even said when she was going through some of the photos that this event was different from this event. She was acting like almost like there are multiple things that are happening. So,
She might have been setting up the sentencing argument. But in the end, well, there's no other way to say it than this verdict was worse than the first verdict, because in the first verdict, at least on one count, they came back with a lesser included, and that jury had a ringer on it. And this jury did not, that we know of, and hopefully this jury won't go out there and blab and go give a bunch of interviews and run on 2020 and say a bunch of stuff that'll make anybody suspicious. I think this jury arrived at the only thing they were left on which to hang their hat, and I think they gave him every careful consideration. It
was. I expected it, but it was shocking when it was coming down, especially after watching the second trial and seeing those verdicts come in not guilty, and of what you call the principal actor in the second trial.
Yeah.
And so then he's going to, and he's being convicted of things that a guy that's been, I guess, given
the guy that was supposed to be the actor,
and so he's
and a guy that's gotten a pass.
He's taking it for. I mean, he's going down with all of them, and that's why you and I, just as I'm sure a lot of people out there like me, you're going like, well, why didn't they just go get all of them that were involved and do
prosecute
the video
all
and go
four?
get all of them, and then not have anybody necessarily escaping because they had a video.
Well, I can say that from my view of the video and the audio. If you were going to cut a deal with any of them, Tip McKenzie's probably the one. He probably was the least culpable person in that room other than Mac Prelude. And I'm not sure that they shouldn't have looked at Mac Prelude. But anyway, McKenzie's the one. But Banks is not the one. It'll always be curious to me that they gave consideration to Banks and then didn't require his cooperation at all. Now, I can see strategically why they wouldn't want him to cooperate, because he was very, very involved as any other of the four. And that would come out on a cross-examination, and that would tend to limit his credibility. But then that begs the question, why did you cut a deal with him in the first place? Because I just can't help but feel that Banks should be punished fairly stridently for his participation in this hard event.
Do we want to be free and speak here and say whatever we're really thinking and be honest?
Yeah, you say whatever you want to say.
No, I'm just saying, I mean, when I see what's going on in the United States, you've got Baylor, you've got Stanford, you've had Penn State, I think Nebraska, I don't want to misspeak, but
you got UT, there's an allegation of a rape at UT. Yeah.
And so you've got something that's going on in the college football world and college athletics where guys are coming and they're being recruited. Louisville,
we don't want to forget Louisville.
I mean,
the director of
you had a lot of heat on
operations.
Louisville.
Yeah.
There were a lot of hate mail coming to you when you got that
When I
girl
had the woman
on
on Katina Powell.
Katina Powell wrote the book. Yeah. And Breaking Cardinal Rules, or whatever the name of her book is, correct?
That is it. That's it.
And so, and then you've got where it looks like they're actually hiring prostitutes for the players.
Well, that's what happened in that case.
And I
I
just
mean,
say,
that's the director of basketball operations hired escorts and strippers to entertain recruits on campus.
when I was at Ole Miss in the 70s, I lived in an athletic dorm because I was trying to play baseball, and the basketball guys were there. There were football guys in our dorm. There were track, tennis. They were filled up. And then the football dorm was next door. They ended up building a new one, and we had curfews and all kinds of different things that kind of guarded the players and stuff. But I remember Sean Toohey, who I'd known in New Orleans. I played basketball for his uncle was the guy named Pete Michelle, and he was my basketball coach down in New Orleans. And Sean was in about 7th grade. He went to Newman, where the Mannings and all go, and I was over a school called Sam Barth. And so when he came to Ole Miss and got recruited, as other guys were doing, me and some of my friends and things, you'd take guys to parties and you'd go out and do some things, but I don't remember any kind of real program that was going on to have girls lined up to be escorting the guys or doing that kind of stuff. So what I'm saying is college sports has got big money coming to it. It's like machinery, and and all these programs and things that are going on to try to get an edge on another program so that guys will come and choose that school to go. Now, in Vandenburg's case and in Beatty's case, they've now gone somewhere where they've gone, and it's happening at other colleges where now if you're a parent of a football player, you really might want to look really hard at the school, because if your kid goes there and he's unsupervised or whatever it is going on with him and he gets in trouble, he could go to jail for 50 years.
Yeah.
And so...
And you got to think that the Brock Turner sentencing and the uproar about his sentence is something that Monty Watkins will take all pains to avoid. And we got some questions here. Chazzy Bass says, long version show, love your honesty. I like to hear more of the day-to-day dealings with Brandon Vandenburg. Do you think the jury knew that it was his dad in the Hawaii shirt? Chazzy Bass, I would say this. First of all, thank you for your kind comments. Secondly, Brandon Vandenburg was not a joy with whom to deal. He was condescending. He was superior. He had a great deal of... He always called me Mr. Long, but it was not in a flattering or respectful way. It wasn't because I was considerably his elder and someone for whom he should reserve any amount of respect. It was more what the unspoken communication to me was we're not friends. You work for me. You're the hired help. Brandon always treated me like I was his domestic help in a very unflattering way. And he and I, it didn't get along at all. Now, I had a job to do, and it was my job to defend him, and I can only tell you that I defended him with every ounce of ability that I could muster, but he and we did not get along very well at all. So it was not very pleasant. If you want to know, trying to work for Mr. Vandenburg was not pleasant. He made demands on you that you thought were strategically and legally unwise. He wanted you to make arguments that you thought would lead to his undoing. I was impressed through my day-to-day interaction with him with the extraordinary chasm of his belief that he had really done absolutely nothing wrong, and I was also shocked and abhorred by it. It would have been a lot easier to work for somebody that came to me and said, look, I've messed up in a big, big way. And I know I'm going to pay a terrible consequence for what I've done, but can you at least use all of your skill and employ and ability and maybe even the threat of having to go to trial with you? Could you use those things to try to minimize the consequence I will meet? If I'd have had a client like that, I think I could have done something. I could have done something for him. But a guy that's doggedly refusing to acknowledge that he had done anything wrong at all, and that it was actually this poor woman who had been victimized that was really at fault, which there was no way I was going to argue that. There was no way I was going to argue
I
that.
actually said that they were almost making him into victim a little bit as the week began.
Well, that was never, ever, ever going to work. Incidentally, this Chazzy Bass, his name is David. So, David, thank you. Somebody says They said they weren't sure if going for consecutive or concurrent Saturday night. Want to say hi to Adam Ellithorpe, who's tuned us in. Hello, Adam. Somebody else wants to know, David is asking, serving in Tennessee, how long his parents will continue to visit. I imagine they're going back to California now. What are the visitation rights? Well, he has to put you down as a visitor, and you can go on the weekends to visit him when he's in the penitentiary system, but I don't know how long they're going to go visit him from California, because, you know, his mother was on a plane when the first verdict came down, was on a plane on her way back to California. I don't know what their relationship was. I didn't meet his mother until right before trial, and I'd been representing her son quite some time. Had never had a conversation with her, and met the dad at trial. Aaron Creighton wants to know, how was it dealing with his dad? He seemed as arrogant as his son. He may have been more arrogant than his son. I'll never forget, and I told this story during the trial coverage. And let me say, I feel like when you experience numbers like what we experienced during the trial coverage, that you probably should crow a little bit about it. And I just want to say, and I'm looking at you because you guys did this. We had 5,100 YouTube views of our trial coverage during the week. 5,100 people watched us, checked in on us, downloaded some video from us, and followed the coverage just on YouTube. We don't know how many viewers watched us on channel 194. There's no way to measure.
Fifth largest city in Tennessee.
Over 5,000 people watched us on YouTube during the course of the trial. I am blown away. That chatter number is and court chatter, we have you to thank, but that number is huge. And if those that want to know if we're going to contemplate covering trials in the future, we're not going to contemplate it. We're going to do it. There are trials around here that are going to need some coverage, and we're going to do it because the response was just amazing. And
the questions that we got, the tweets, we couldn't answer all, but and we're set up here with a phone. We had a lady from, I remember from Detroit and some other people that called in, but we were on a cell phone.
All right, I've got some more questions here. Lynn's B, I'm curious why you think they should have looked at Matt Prelew. You said last week you would have asked him, wasn't he the one raping her? Well, the reason being is there was a piece of evidence the court excluded that I've seen. And it was a communication between Prelew and a buddy talking about some girl that had, his words, puked balls out on his floor, which there was vomit in this case, and had and some intimation from the other guy saying, well, what did you do? Did you do anything to her? And a ha ha ha, kind of left it out there that he may have. Now, it may not have had much evidentiary merit, and the young man said that he was referring to something that happened after this event when he was back in Texas, and I don't know that he wasn't making that reference. But and Prelew may have had nothing to do with this whatsoever. It may have been just like he said, that he was in there feigning asleep and just didn't do anything. But anytime you have a suspect that is cleaned up a crime scene, that has made this kind of reference that was made that was somewhat proximate to the event 2 weeks later, and it was puts himself in the scene during the event, just feet away on a bed. It's inconceivable to me how he gets immediately ruled out as a suspect. His bed doesn't get processed. I don't know. That's just not what I came to learn in 18 years of law practice to be standard operating Metro Police crime scene forensic method of operation. I don't understand that. So he may have had nothing to do with it, but then again, we don't know because it was never really investigated. Somebody says, great coverage. This is from Adam Ellithorpe. If you couldn't win this case because he wouldn't listen to your advice, then he got what he deserved. You were the best for a reason. Thank you, Adam. It's very kind for you to say. I've still got comments coming in here, so everybody kind of hang with me.
Back to the other stuff. When you've got, you get access to a lot of information that doesn't ever get to a courtroom in front of a jury, right? Both sides are battling, trying to keep.
Oh yeah,
stuff
there's
out.
lots of
So
information
war
you
runs a
get
lot
in
of
discovery
information
that
on-
gets
yeah.
excluded. Sure.
This is my amicus brief that went to the Tennessee Supreme Court, and it was about because there was a thing there. They got 400,000 text messages, and basically the Supreme Court came down and said you can't get them.
Well, and I need
And
to
so I
bring
don't
this
know what
up
that-
because you keep referencing that. I need to bring this up so viewers know. A brief amicus curiae means that you're not a party to the proceedings, but you've asked the court to intervene and supply a brief on the issue. So I just want everybody to understand
Well-
what a brief amicus curiae means.
Yeah. And
Because
so-
you've used that term, and I don't want them to not
Well,
know what that means.
I don't even know what it means either, other than.
Well, now you
that's-
know.
Yeah, thank
Yeah.
you. But the reason was because I got banned from the first trial, and so I had the information, and so I gave it to him as a friend of the court. That's what you really are doing. You're basically saying you're a friend of the court, and you're trying to give them information so that they can know.
All right, I got some
things
more.
they might
I got
not.
some more questions here. How many years is Beatty looking at? I think you and I talked about 18 as your guess. Yeah, Tammy, and this is from Tammy. Tammy, I think he'll get 18 years. I can think of some enhancement factors that the court could consider, which would make his time more. But I can think of a couple, 2, 3, maybe 4 mitigating factors that would apply to Beatty. Now, alcohol is not a defense to the offense, no matter how much it's been tried to be made one. But it can be a mitigating factor at sentencing. So you're going to hear the inebriation evidence again at sentencing. I think he'll get 18 years. I think Vandenburg will do worse than that. I think Vandenburg, if he's lucky enough to be sentenced concurrently, and I don't know that he will get 23 or 4 years. Somebody named Hanau says, do you expect Vandenburg to get significantly more time than Beatty? Well, yes, I do.
Yeah.
I just answered that. I was able to get the answer out before the question. I apologize for that.
Does he get more than Banks?
Wait a minute, got a call, and we're going to. Hello, you're on the long version.
Hi, Fletcher. This is Brenda Detroit. How are you and I?
Brenda,
Hey,
how
Brenda,
are
how
you
you
doing?
doing?
We're so glad to hear from you. Let's turn her up.
Hi, everybody. This is Brenda from Detroit, representing CC or CourtChatter.com, as we love to say.
How are you
How's
doing?
everybody today?
Oh,
We're
we're
fine. How
doing
you
just,
doing?
you know, what'd you think about our having 5,100, over 5,100 views on just YouTube? What a coverage.
That was pretty good. That was really well. I thought you guys did such a wonderful job.
Well, thank you. She's
You
up in
know,
court.
you had to compete with Nick, and it was 2 different types of coverage.
Yeah.
However, both of you all brought different perspectives, and we all enjoyed both perspectives.
Hey, Brenda, I just want to say, now that I'm no longer competing with Nick for viewers, I really like him. All right, I just want everybody to know, I want everybody to know that.
And I hate that Saturday I didn't get a chance to watch the verdict, but I had to leave out. But anyway, I did get a chance to see it in Court Chatter's archives. But I had a question for you.
Yes, ma'am.
Given the level of depravity and the assuredness of Brandon that this young lady was not going to wake up, I know that there wasn't any concrete evidence to support it, but do you believe, or would you be surprised to find out that she was in fact drugged, and would you be surprised to find out that he's done this before? I just don't think that he was an amateur.
Well, let me say, Brenda, that there were some, and you know, I've told about the Prelude situation got excluded, but there was some evidence the state wanted to introduce that maybe Brandon had done something like this before, kind of an inferential appearance that the court excluded that too.
Okay.
So I would not be too terribly surprised. That would not have been something I would have wanted to know because it would have impacted my ability to argue for him and some of the things I might say. But I would not be terribly surprised. And the blue drink issue, do I think that Brandon gave her a knockout drug? I don't know what to tell you. Because I think it's a fair inference.
Kind of fuzzy or
That's a fair inference. I think that's a fair
kind of,
inference.
on the fence about the blue drink, whether or not it had anything to do with it. It may or may not, but it was just something about him that made me feel that this was not his first time. Maybe it was his first time going as far as perhaps videotaping it and getting others involved. But he seems like a baby psychopath, a sociopath. He seems like he could very well have easily went down that path had he not been stopped,
Wait.
because there was a sense of entitlement.
You know, Brenda, I'm no psychologist, okay? I want to start out with that.
Just play one on TV.
But yeah, but I can play one on TV if anybody's hiring. However,
Okay.
I think that if you've ever looked at the DMV-4's definition of sociopathic personality disorder, and I have, you will find some similarities between what it lists as characteristics of sociopaths and what you've noted in Brandon's actions and appearances and affect. So
Even his demeanor during the trial.
Yes.
Even his demeanor, as far as there was a couple body language, a couple gestures that he made when someone was on the stand. I can't remember who it was. That just did not seem. If I was on a jury, I would not think that he was remorseful.
And those type things, those nonverbal cues in jury trial work are so important, Brenda.
Mm-hmm.
That jury looks at your client and they make decisions based on his affect. Does he appear to be sorry? Does he appear to be above the proceedings? Does he have a dogged insistence that he'd done nothing wrong, and does he omit that affect? Jurors are interpreting that in jury trials, even if you don't believe they are, and even if a comment is never made. But how you present yourself in a jury trial is so utterly important, because it's one of the ways the court instructs a jury to determine credibility of a testifying witness. It's in the court's instruction.
Mm-hmm. Well, thank you guys so much for taking my call. I don't want to hog all the airtime, and I really appreciate your coverage and your inside information. Thank you so much.
Yeah, Brenda,
Thank
but
you,
listen now, don't tell Nick Barris how much I like him.
Okay.
Okay? All right.
I promise I won't, but thank you all so much. Have a good day.
Thank
All right,
you
Brenda.
too.
Bye-bye.
Now we're going to try the inexact science of hanging
Hanging
this
up.
phone up. See if we,
There it
well,
is. Yeah,
figures
got
on
better.
day 6, we'd get it. We've got some more questions here. Aaron Creighton says, long version show, no surprise, I'm a former bartender at the Tin Roof, and I went to the first trial. Hello, Aaron. Hello, Aaron.
Wow.
I looked at Kay Seitz like she's Aaron. I don't know what drew me over there.
I don't know. And
All
don't
right.
say anything derogatory toward Kay.
No.
You got chastised.
She's
Y'all
fantastic.
got
No, I didn't say
chastised.
something derogatory.
No, I'm talking
Yeah.
about demeaning to women and everything.
Oh
You know
yes,
how
no, I don't want to do
sit down
that.
on
If
the
you
radio
ever listen to my
yesterday.
radio show, we got
That was
probably rightfully,
And,
but
and
we got
hopefully
lectured.
she's
Yeah,
watching because I like her.
yeah, I do too, and I agree with what
Sex
you had to
Evolution,
say.
I think is her name.
Yeah, but anyway, it says I was a bartender at the Tin Roof, went to first trial. Brandon's dad was like his bro, was expecting a chest bump on the break. Brandon's dad's demeanor, affect, terrible, horrid. He got called down in the first trial for putting his feet up on the rail with his shoes off. I mean, could you ever evince less respect for your surroundings or the proceedings than to take off your shoes and put your naked feet up on the court's bar? You know, that's the bar. When you go before the bar, that's the bar that you have to be a member of the bar to go before.
in.
He puts his feet on it like he is. I cannot even, I have no words. I have no words. Not to mention the fact that I hadn't been paid in months, and he's showing my wife pictures of his beach house, which I have to wonder what that was all about. I think I know.
And
I want to ask Aaron Creighton this, though. Aaron, if you don't mind me outing your identity, do y'all have blue drinks for sale at the Tin Roof? Yes or no? Tweet that out to me. I got another comment.
I want to say one thing. Your closing arguments.
Okay.
We talked about this on the radio today.
In the first trial, my closing.
And I asked you the question because I said you and I have spent 3 years down there in these courts, and I've been down there with all these lawsuits.
Well, I
and
spent
all
more
this
than
stuff.
3.
Well, I'm talking about my 3.
Yeah.
I was a virgin to the courts, but I'm not anymore. But anyway, you were down there, and I said, have you ever been down there where you had no money to pay for the parking? Because I know I've had it. And so I just was curious about that. And you said it down the radio show that on the final day when you had to go do the closing arguments and go into the ring and basically go to war for him, that you couldn't pay for the parking.
Yes, I was I had to park in the court's garage that day because Warwick Robinson's lot was full, and it was $12. I was going to be there all day. It was $12. And you know, when you're trying a high-profile case, your other clients stop paying you because they know you're on TV, they know you're tied up. It's like being on vacation. Those of you that are independent in business people, do you ever tell your support staff to tell customers you're on vacation? I mean, you think these people are going to make their payment to you when you're on vacation? No, they don't do that. So you tell them what? Well, he's not available, or he's in a meeting, or he's in an out of the office meeting. But you tell them stuff to make them think he's working or she's working because you want them to come in and pay their bill. They're not going to do it if you're out of town or if you're on television. You know, I couldn't even tell my clients some lie about what I was doing because they could turn me on and see me. And so anyway, I wasn't getting paid by anybody else. I'm down there to argue the case, and I am so broke. You know, every problem that I was experiencing in my life at that moment, from inability to pay your mortgage, can't make your car note, your kids can't go to the roller rink party because you don't have any, all of these problems were directly related to the guy that I'm having to fight for fist and wrist. You have to be a professional to do that. It's hard to do that.
Yeah.
Because I can't tell you what people, you know.
I think he would have needed you in the closing argument here.
Well, David says he is a control freak then, felt the whole trial he was directing the entire defense because BV knows more than a lawyer. Oh boy, did you ever hit the nail on the head there. And I told this story on my radio show. And Aaron, I'm still waiting on you to tell me if y'all serve blue drinks. But anyway, I told this story on my radio show. Shortly before the trial, the first trial in the matter, Mr. Vandenburg, who called me Mr. Long because I was the hired help, we've been over this, had me go in on a Sunday to my office, demanded that I do it, and told me 2 weeks before trial, he told me that he was tape recording the conversation and I was to be in there alone. Now this was not a, do you mind us talking alone? This was, you are to be in there alone. Yes, sir, Mr. Vandenburg. He then gave me sort of an oral examination, and I don't know if he thought I wasn't doing well enough or something. He makes the comment to me, he said, you know, Mr. Long, I would take this test for you, but the law won't let me. So you're going to have to be prepared for this test independent of me. And I'm sitting there, I can't even tell you what's going through my mind. You know, because you know we've well established he's not even paying me. And I'm sitting there, I'm getting lectured on how to try a lawsuit. I've tried at this time over 200 criminal jury trials, and I'm getting a lecture from a 19-year-old whose strategy has been on full display, video, audio display. And as a strategist, I was unimpressed with his ability to arrive at a plan and carry out the plan with effectiveness. I would have to say that his performance left a little to be deserving, or left a little for the wanting, or whatever. So anyway, good Lord, did he think he knew more than I? Are you kidding me? I've never been around anybody near as superior as he. Let me see here. I'm still waiting on the answer on the blue drinks.
And in contrast,
is he a control freak? Yes, he is. That might be the least of his problems. Stevie G says, just to let you know, the Terminator said he would go for consecutive sentences on ag rape and the photos. Those happened on 2 different dates. So if he did that, I think the photography count was it's an E or D felony. If it's a D felony, it's 2 to 4 years. If it's an E felony, it's 1 to 3 years. If it's a C felony, it's 3 to 6 years. So let's assume I don't know what it is. I don't have to know those type things anymore. I'm now a radio guy. I know a lot for a radio guy, but I'm a radio guy. Let's say you got 3 years for the photography count and 20 years for the rape. That'd be a 23-year sentence if it was
what about sexual
consecutive. Huh?
About aggravated sexual
Well,
battery?
according to this viewer, what he's going to try to have sentenced consecutively is the photo count, the illegal photography count, and the ag rape count. Now, another viewer says, as I thought in the last trial, Perez looked like he didn't believe his closing argument, especially when both were inebriated or drunk. I think Perez's strong suit is not, I don't know what it is, but it's not speaking from the heart extemporaneously. That is not Perez's thing. That's why he has 27 trial notebooks. You don't walk into a trial with 27 notebooks. And you notice it hurt him during his presentation because during the trial he would have to refer to this written document all the time. We were always having to wait for him to find some note or handwritten note or some document, or it hurt him a transcript. It hurt him in his closing argument.
Yeah.
He does not have an ability to make a connection. That's why I thought it was a poor decision to have him give the closing argument in the first place.
He also built it on intoxication, and the other thing is that, and I don't know, it was a fine line, but that the victim's sitting there, and you really don't want to be even coming close to blaming the victim or to.
They wanted to so badly. They wanted to blame her so badly. I mean, I could tell you things about what they wanted to assert that would make you burn them in effigy. They wanted to blame her so badly. They didn't want to blame Brandon. And see, the only thing they could come up with as a defense that was something other than Brandon is really basically a bad guy was this intoxication. And what about Vanderbilt? And why didn't they supervise him?
You're getting good.
All right, this is Kathy Russin. Kathy, welcome to the long version. You're certainly no stranger.
Hello, Fletcher and Austin. How are you guys?
Hey, Kathy. How
We're
you
doing very well, Kathy.
Hey, first of all, I want to thank you so much for the coverage on this trial. We have never had so much insight into a defendant before on a trial that we've covered, and so I have really appreciated it.
Well, thank you so much. And I'm sorry to the extent that my ability to give insight is limited to my former experience. I mean, I've never been a prosecutor, so to some extent trying to give you, I've always seen it from the other side of the fence because that's what I did.
Well, no, I appreciate that. Hey, I just want to quickly say that Erin tweeted back, because I asked her too on Twitter, if they serve blue drinks at the Tin Roof, and she just wrote back and said, absolutely not.
Oh, wow.
We had blue Curacao, but do not remember ever, in capital letters, using it.
Wow.
Yes, Andy was not a booster, which I think I probably reported that, but I reported it because I heard others report that previously.
Well,
so Andy was not a booster.
From the time I took the case.
So they did have, I guess, a liquor called Blue Cartel there, but she does not remember it ever being used, and she says they did not serve blue drinks at the roof.
Well, you just answered one question in criticism that I would have had of the defense team, and I told Warwick Robinson before his trial that he needed to subpoena the manager at that bar and have them testify to how many blue drinks they serve, and he didn't do it. Well, he must have gone and talked to somebody and heard what you just told us and said, good Lord, if I subpoena someone from the bar and they say, well, we've got the ability to make a blue drink, but we never sell them, that's going to make it even worse. I'm going to be proving that for them. So that may be...
So then my question is, why would the state put a bartender up?
Well, I think the state felt that they could get there inferentially, and I think they did. I think they got there. It's hard to criticize a complete and total victory. I mean, one of the worst things about trying law and not practicing law, and when I was a criminal practitioner, there was one stretch where I won like 64 straight criminal jury trials in Robertson County, Tennessee, where I principally practiced. But you have a tendency when you're winning to not ask the questions you would ask if you were losing, because you figure, well, I must be doing something right because I'm winning. Well, not necessarily, and you probably still need to go through some self-investigation even after you win, but we don't tend to do that after a win. We tend to reserve that for when we get a result we weren't expecting.
Right. Hey, so I wanted to talk about my favorite pet peeve of this entire case,
Okay.
The Mackenzie Banks angle. Yeah. And also it was asked by one of the viewers. We always talk about my favorite soapbox issue about them, and they're not going to be tried, although, there's no official word. So after the verdict, when they did a press conference, General Thurman, announces his retirement.
Right.
So he's retiring, so if they are going to be tried, he's not going to try them. Isn't that telling? That's telling to me, at least. Secondly, he was asked, the reporter asked him, when will those trials be? Are they going to be tried? And he says the wording was everything. He says, well, just like every case, we will be entering plea negotiations with those two defendants, And if a plea cannot be reached, then pause. We'll take it to trial.
Well, that is telling because it's not like every case, because I can think of one case where there were no plea negotiations, where I made a wasted trip.
That was my comment exactly when he said that. I thought, no, there was never a plea offered to Brandon Vandenburg.
Yeah, that's right.
That would be if I have a criticism of the prosecution side, is that they've got a video and they got 4 guys, maybe more, who knows, and that they're not prosecuting them. So there's a lot of selective things about who gets off, who doesn't.
I will never, for the life of me, understand why Brandon Banks gets to plea. Based on the evidence I've seen, you've seen now 3 times, Kathy. I've seen it more than that. I will never understand what makes Brandon Banks any less culpable than Beatty.
Here's the only way that I will understand it is if the victim is on board with it. If she's on board with it, then I am on board with it.
Well, she may be.
She doesn't have to go through it yet another time, and they come up with some kind of plea that puts him behind bars for a time. I just don't think that's going to happen.
I would be very surprised. Maybe Banks, I don't think Lane College vets this situation and gives him a scholarship if he's going to be headed off to jail. So that tells me a lot, unless they put it off to when he graduates. But
maybe.
I don't know. But Kathy, I know this. You're the best at what you do. And you, our numbers, I don't know if you heard, were through the roof. They were absolutely, we're blown away by our numbers just on the YouTube. We don't know what the local television coverage was. I can tell you this, a gentleman, when I gave the talk at the SAR dinner about Flag Day, hobbled up to me with a cane and said he's been loving my coverage, and I'm pretty sure he can't spell YouTube and probably doesn't own a computer. So he's watching it somewhere, but I'm going to tell you the numbers were just phenomenal.
Well, I'm glad that you had the coverage, and I agree with what Brenda said, because many people did like the other station's coverage. We carried Channel 5's coverage as well on Court Chatter. We also had their producer in our chat room, so I have to give a little fair all-around kudos out to everyone. I think there was a lot of good coverage on this case. We had your unique insight, which is what I love, because I've worked with a lot of different attorneys and reporters across the country on cases, and have had a lot of different inside information on cases, but never like this, because when do you ever get to have the defendant's attorney? Never.
Never,
So that's what made this one unique, and I really enjoyed being able to get some scoop from you. I thought that was great, and I enjoyed that, some people, you're kind of a guy that just says it how it is. Some people don't appreciate that, but I actually really like it, so I've enjoyed working with you.
Thank you, Kathy. I've enjoyed working with you.
All right, I'm going to stop, so you can continue on with your show.
All right, thank you. What a wonderful person Kathy is, and she's not just supported this TV coverage either. I can't get it off. There we go. She hadn't just supported the TV coverage. She's been on my radio show numerous times and listens to that. So I so much appreciate her. Somebody says Vandenburg needed a closer and didn't have a chance with those other lawyers. You were his only chance. He should have listened to your advice and used your strategy. Well, let me say this. I never had a strategy there was no strategy, in my humble opinion, that would have netted him an acquittal. The only thing I could have done is talk the jury into coming back with maybe a B felony, and I could have cut his prison time in half. That would have been a home run. And I was asked before the first trial by 2020 News Team. It was a producer for 2020. His name was Joe Diaz, for whatever it matters. But he asked me, he said, Mr. Long, are you going to win this case? And I said, I am confident that I have the ability to have the jury return a verdict that I would consider a win. I have zero belief that I can have the jury return a verdict that Mr. Vandenburg would consider a win. Mr. Vandenburg wanted an apology, and he might have even wanted us to pay him some money for all this trouble we put him through for nothing and needlessly. He wanted to, he was worried about, there was one time when NBC New York wanted us to fly out and do an interview, and they entered what's called an embargo agreement, or they drafted an embargo agreement that I was going to have some editorial content about anything they ran pre-trial. In exchange, if they wanted to run something post-trial, I couldn't say anything, or I could pull the plug on anything running pre-trial. I thought it was a good idea to do it because I was going to be able to watch Brandon Vandenburg get, in essence, cross-examined. He was going to be interviewed. He was going to be cross-examined by somebody like a Diane Sawyers or somebody along those lines, and I was going to be able to make a determination as to whether or not it would be wise to put him on in his own defense, see how he bore up to the questioning. Since it wasn't going to get aired till post-trial based on my call, if he'd have said something particularly damning, I just would have pulled the plug on it. I had it all in writing. This was all in writing. Vandenburg pulls the plug on doing the and incidentally, we were all going to get a free trip to New York. Not that that matters, but NBC was flying us all to New York. But I assure you that had nothing to do with my desiring to do it. Vandenburg decides that we're not doing it because when this thing was over, he still hoped to have a career as a broadcaster with ESPN. Are you listening to that?
Yeah, I just heard that. How's that going?
No, Brandon, I hate to tell you, son, but the ESPN gig is over. You are not going to ever work for ESPN. I cannot believe that. Can you believe that? That was that guy's assessment of his culpability or even exposure. Got another question. Will Vanderbilt have any responsibility in this?
Oh.
Lynn, not really in any tangible way. I think
Baylor did.
I don't know. I don't know the answer to that. Do I think that Vanderbilt deserves to bear some responsibility in this? I'm going to look you right in the eye and tell you. Absolutely. Absolutely. I think they do. I think Stanford does. If UT's assault occurred, I think they do, and I'm an alum of UT. But we have got to do something, people, about these athletic programs, this sense of entitlement, and this belief that we all exist for their pleasure. You're on the long version. Thank you for joining us. Hello. That might have been something that was somebody that was calling for Sights and Sutton. Oh Lord, I can't get the thing to time. There we go. All right. Kay, your dry cleaning's ready. I think that's what that was.
Back to Vanderbilt.
Back to Vanderbilt.
That's a big question.
Don't you think that they have some responsibility?
Well, I looked at James Franklin's tweets over the weekend. It's Father's Day with his children and stuff, you know. And these guys are running big programs. They basically call them CEOs. When I was a guy, you know, younger, and Bear Bryant and guys like that, when they were coaches. I remember Bear Bryant benched Joe Namath before the Sugar Bowl or something back in the early 60s. And coaches disciplined players and try to get their attention, try to do things to. I had a kid that played for me that was a headhunter, great kid, but we got to a baseball championship game one day. We had 9 players, and we told him not to go swimming in the swimming pools, and he went in the swimming pool and burned the bottoms of feet, and he can't have his shirt tail out and everything. And me and one of the coaches took him out, and we said, "We love you, but you ain't playing today. This team's playing with 8. We're playing another team with 8. In a 9-man game."
Yeah.
And he had to sit. We said, make sure the dugout's clean. The reason you're doing that as a coach is because there's something bigger. You're trying to teach kids, and you're trying to affect their lives, and you're trying to instill something in them. And so a lot of these CEOs, I guess, that are running these college programs, they seem to me to be, it's gotten to be so much money and so much pressure or whatever it is doing. But at the end of the day, you've got a bunch of young kids that come to your colleges and that are under your responsibility while you're there. I look at somebody like Coach Corbin, incredible guy. I mean, he represents everything about Vanderbilt that you want, just out of the kind of coach he was.
Has the most successful
Same
program
thing
there.
with
Yeah.
I think Coach Stallings was the same. I think the guy that got him. My dad went to Vanderbilt. I love Vanderbilt. My father-in-law helped to put the Hawkins Field in over there, and do the things he did. But you've got to have the right kind of men. I think Coach Mason. I've talked to Coach Mason. I think you got to have the right kind of guys running a program, and to me, Vanderbilt got off the mark a little bit. And Franklin, when I looked at his tweets, he doesn't say anything. How do you coach guys and recruit them and sit down with parents and say, we're going to bring your kid all the way across the country and then get them there, and then they're on campus 3 weeks and then they end up going to jail for the rest of their lives while you're off coaching somewhere. I That's hard to say, but I think there should be some introspection into that.
All right, somebody says, Fletcher, what do you know about Vandenburg's mother? Not much. I did not meet her until right before the trial, which I thought that was kind of odd. You know, I'm representing your son who's accused of an A felony offense for which the minimum sentence is 15 years at 100%. I had never had the first conversation with her. I'd never met her. She seems like a nice lady. She is a teacher, but I don't know much about her. I know that Brandon's dad and his mother are divorced, and his dad brought his second wife to the first trial, and he comported and acted like a complete and total ass, even down to what he wore in court this time, the Hawaiian shirt. I thought, you know, why do you want to give off that affect? You know, I just thought that was incredible. Somebody else says, long version show, that says it all for him. Seems he thought he would win and sue everyone, including the victim school. Did you ever get paid? No. They stopped paying me. They were paying me monthly, a stipend to do the case. And pretty much from the time that I got arrested in that case that ended up being dismissed because my phone record showed I hadn't done any of it, but I think the whole point was to put out the negative, pejorative black person references because this case was being tried to a black judge. But pretty much from that point forward, he kind of stopped paying me. He might have paid me 1 or 2 months in there, but he pretty much stopped paying me from that point forward. I think he reasoned I was just lucky
so you
to
got
have.
no money for parking. You're getting arrested every other day while you're in the trial. It was a pretty hell of a
It was
trial.
it was hell on earth. Okay, we got about 3 more minutes left. I can't leave the air without thanking First Choice Moving and Storage. They really were our principal sponsor for this broadcast. All you people in Clarksville should thank them and do business with them. They should be your first choice because frankly they're the only choice because they are the best. They are down there on College Street here in Clarksville. I think it's 1330. Their phone number is 931-920-5455. And I also want to thank Justin Swallows, the host of the Saturday Sports Splash. That airs Saturdays 10 to 11 on WJZM News Talk Radio. That's the same station where I principally broadcast. And just a fantastic guy, and he has a fantastic show, and check him out. And also I want to thank A Way Out Bail Bonds. You can reach them at 931-553-8991. That's their Clarksville number. Now, they have multiple locations. That's their Clarksville number. Every now and again, people, we got to have a way out. And if you're in jail and you want to assert your innocence and you're going to have to gain your liberty in order to help fight that battle, you need to call my friends at A Way Out Bail Bonds, 931-553-8991. Folks, it was a historic broadcast. We had unbelievable numbers. I cannot leave the air without thanking my co-host and friend, Austin Davis. Austin, you were fantastic. Your clothes on Friday when I went to see my son, when I went to my son's banquet, just one of the outstanding moments on the trial all week long. And you really, you know, Steve Sawyer and I were the executive producers of this broadcast. Steve was its director, its cameraman, its grip. He was everything. And this was a historic landmark broadcast for Clarksville, Tennessee. And I think Clarksville made its point. I think we showed that we're as talented as anyone, that we can put on a first-class, first-rate live broadcast of trial coverage, and I feel like that's what we did. I feel like that's exactly what we did. And of course, I got to thank Kay Seitz at Seitz and Sutton for having the foresight and the belief that we could do this. And in the end, it was a terrible human tragedy. The entire event, it was Gettysburg. There were dead bodies everywhere you look. And all of these lives, this was a I'm going to go back to what Warwick Robinson said in his closing argument, and you may not agree, you know, with the sentiment, but it was somewhat of a true sentiment that 6 minutes irrevocably altered the lives of 4 people, and a fifth one that we don't want to forget, and that's the victim. Irrevocably altered, irrevocably changed, irrevocably broken. 6 minutes. So if you're a kid out there, we really want you to take into consideration what you're doing. Tune me in on the radio. Follow me at Long Version Show. You've been getting a special edition of the long version, we're out.